Hi, this is Quintella Griffin with Better Homes and Garden, aka Agent Q. And today I'm going to be doing a presentation on handling a probate sale during COVID-19 pandemic with Agent Q. Hold on, let me. So the reason why I decided to cover this topic is because I'm a certified probate real estate specialist, and I run into a lot handling probate sales, and a lot of people want to know the difference between what is full authority versus court confirmation versus how probate sales are going to be handled now during the COVID-19 pandemic and the reopening of the superior courts in California. So I'm just going to touch on that basis. If you have any questions, feel free to ask me. Disclaimer, I have to give this disclaimer before I start. I am not an attorney. This video is for informational purposes only, and it should not be taken as legal advice. You should also seek legal advice about your probate sale from an attorney if you have legal questions. So make sure you do that. Thank you. Let's start off with what's probate. I'm going to cover this topic because not everybody knows what a probate sale is or what probate is in general. So probate is the legal process that takes place after someone dies. It includes proving in court that a deceased person's will is valid, identifying, inventorying the deceased person's property, having the property appraised, paying debts and taxes, and distributing the remaining property as the will indicates or directs. So probate happens when you die without a will or with a will, either way. The only way you don't end up in probate is if you have a living trust prepared, a TOD, or any types of forms of the way the title is held, like if it's a husband and a wife, and the title is held husband and wife, or as joint tenants, it passes to the next tenant, or if it's husband and wife, it'll be community property with survivorship rights, which will just pass on to the next person, the next spouse. So you won't end up in probate under those circumstances. But usually if there's no living trust, no TOD, then you're going to probably end up in probate, especially if you don't have a will. And this is something really important. Everybody needs to get their estate planning done, because the coronavirus is killing people. And a lot of people are going to be dying without wills or have died without wills that are going to end up in probate. And this is going to be, it's already a lengthy process. It's going to be extra long due to the fact that what's going on with the courts and the way paperwork is being processed now. So let's start. In probate, there's two types of probate sales. The first one is full authority versus court confirmation. So this will determine how fast you close escrow. So one process is just going through the probate, getting your petition, getting your letters and your probate order, which is quick. That's the one on the left. They look the same, but they're different processes. And then the court confirmation is a lengthy process where you have to go through court. You have to get the judge to okay the sale. You have to put down a deposit. It's almost like an auction. You have to bid. The process is much more lengthier. So let's touch on that, and then we'll go through this whole entire process. So with the full authority, you're going to need letters and a probate order to close escrow. And that process is much faster. And as you can see over here, I have, and this is from a probate sale that I did, in the executor, or excuse me, the personal representative in this sale had full authority. So you see right here on the letters, full authorities, it's got to have a seal on it. The personal representative has to sign the document, and her attorney prepared it. as you can see. So that's how this works. Then you see where it says order for probate. You see my cursor going across here. She was the executor, authorizing independent administration of estate with full authority. And as you can see in this order, you know, you can zoom in, I'm not sure. It tells you right here where it says warning, this appointment is not effective until the letters have been, I think it says signed by the judge. So that's the way that works there. And as you can see down here, they put who the California probate referee was, the contact information. So if you are selling in probate and you have full authority, once you file the petition and you go to the hearing, once they confirm who the personal representative is or the executor is, your attorney will prepare what they call letters and an order for probate, and boom, you go put the house on the market, because now you have authority to sell. And this is what you're going to have to give to the title company. These two documents that the title company needs. There's another document that the title company needs too, which we will talk about if you decide that you want to list the sale with me. But these are the two documents, letters and the order for probate if you have full authority. So I'm talking to you, personal representatives, executors, special administrators. You do not have to wait till you complete the entire probate to sell. Once you have these two things, this is all you need to do to sell the house and put it on the market. Now, here is the process for a court confirmation. So this is the difference, and I want you to see the difference in the way it's done. So is court confirmation required for a probate sale? No, it's not. If the personal representative or executor does not have full authority, then you're going to need to go through the full, you're going to have to go through the petition to get the court confirmation to sell the property. You won't be able to just take the letters and the probate order and take it to the title company and open up escrow and go, okay, I'm ready to sell, and you won't have any more interference with the court. So when you don't have full authority, you must get court confirmation. So the judge has to approve the sale. Court confirmation is a lengthy process. Number one, marketing a probate sale. In a probate sale, the property is marketed just like any other property. The probate attorney or the estate representative will hire a local real estate agent, sign a listing agreement just like he was if it was a regular sale. So that part is no different. Under court confirmation, making an offer. An interested buyer may make an offer on the property at any time. However, in the case of a probate sale under court confirmation, the offer must be accompanied by a 10% deposit. The estate representative will then accept or counter the offer just like any other sale. The offer is subject to the court's confirmation. Even though the seller may have accepted a buyer's offer, the seller is not committed to that buyer or their offer because it has to be confirmed by the court. Remember that, you guys, when you're making offers on probate properties, you need to find out if it's full authority or court confirmation, because the processes are different. I try to direct my clients when I'm taking buyers out and they say I want to buy a probate property, I try to always direct them to full authority probate sales versus court confirmation. We can do that too, but it's my preference to direct them to court confirmation, to full authority sales, and I'll get into that and tell you why later, because it has something to do with money. Third thing, playing the waiting game. So with court confirmation, you got this waiting game. Once the sale date is determined, the parties now must wait a minimum of 30 to 45 days. During the time, the court requires that the property be properly advertised and marketed with a new accepted price. In California, for example, when we're talking about a probate confirmation sale in California, the court will take that accepted offer and raise it by 5% plus $500. The total becomes the new probate price to be marketed. So you do understand that, okay? I'm telling you this information, but if you want to have a consultation and talk about the probate process in depth, you can book a listing appointment, or you can book an appointment with me and we can talk about this in depth. I'm sorry. Court confirmation 4, going to court. In order for the sale to be confirmed, the court requires that the new buyer plus any other interested parties, get this, other interested parties, come to the probate court to confirm the sale. So you might show up at the court hearing and it might be other people that want to bid on it. So keep that in mind. The property is then sold auction style, with the opening bid being, in the case of California, the accepted offer price plus the 5% $500 increase. Sometimes multiple buyers will show up at the bid to bid up on the property in increments of $5,000. If nobody shows up to bid on the home, the first buyer gets the property for their original offer price. If the property is sold to one of the bidders, they must immediately hand over the deposit of 10%. So keep that in mind, that you might be going to bid on the property by court confirmation, but that doesn't mean that you're actually going to get it. You might get outbidded. So just keep that in mind. Be prepared to increase your offer price. Next, court confirmation. Number 5, the deposit may not be refundable. And this is why I steer my buyers who are looking to buy probate properties away from court confirmation sales, because you might not get your money back. And that would be an issue. 10% is 10%, and people don't have money to be giving it away. So I try to encourage my buyers to do full authority probate sales. So there are some things for buyers to be aware of when moving forward on a probate sale. With court confirmation, not full authority, but court confirmation, many times the 10% deposit that's required with the offer is not refundable unless the original buyer isn't the final court confirmed buyer. Also, since the seller is deceased, remember this, so when buying a probate property, with the disclosures, you're not going to always, the disclosures are not going to be like the disclosures with a regular sale, because the person is deceased, so they can't really disclose the items that were wrong with the house, because there's nobody there that can do that. They died. So there usually isn't anyone to disclose previously leaked windows, illegal work done on the property, plans for major change to the neighborhood, or anything else that may negatively affect the property's value. But usually the executor or maybe family members can kind of give you a little bit of information, especially if they've been living in the house. They have some idea of things that could be wrong with the property or the condition of the property. So some of the information may be available. COVID-19 and probate cases. The obvious is probate courts are backlogged from closure. So your case is not going to be heard fast. This is a process. The courts are kind of going to be tweaking with this. So you're going to have to be patient when you file your probate case, when your attorney files your probate case. You're going to have to be patient with your attorney and understand, you know, that he can't move any faster than the court allows him to move. It will take longer to get your hearing dates. Remember that. When your attorney tells you it's 3 months out or 6 months out, he's telling you the truth, because of what's going on with the COVID-19. It's delaying the cases. And then you have to take into consideration that prior to the courts being closed and the shelters being implemented, that those cases were continued. So they may have been continued more than once. And so now that the court is reopening, those cases are going to have preference over new cases. So that's where you stand, and that's the impact that COVID-19 is going to have on probate cases. Heaven forbid if you need to extend a request of continuance. It's going to even delay you getting letters, you getting a probate order, the court confirmation process is already long, it will just make it even longer. If you had a court date calendar before the shelter, you probably have a better chance at getting your letters and probate order and or getting your court confirmation sale completed in several weeks. Just simply don't depend on it. If you are a savvy personal representative, executor, or heir or beneficiary, if you know how to use the court's docket, and every court has one where it's usually called like public access, you can go into the court's docket and check on the status of your case without even bothering your attorney. I'm a certified probate real estate specialist, and I used to be in the legal field before I became a realtor. And so I know how to check the court's docket and see what the status is of the hearing and when you can anticipate getting your letters and your probate orders. And I could kind of like direct you to where that website is so you can check it yourself, so you don't have to keep calling your attorney. Did we get the probate letters? Did we get the probate letters? Did we get the probate order? Can I sell? Can I sell? Can I please sell? So just keep in mind that this is going to be a delay. Now, I predominantly work in Contra Costa and Alameda, but I also service all of Northern California, San Francisco County, San Joaquin County, Sacramento County, all over Santa Clara County, all of Northern California. But I just wanted to touch bases on my two favorite counties. So Contra Costa, I highly recommended that you check the court's website for updated rules, as they are subject to change. And this is with any superior court in California, not just Contra Costa, but every court in the state of California. All the counties are going to have their own rules, and you're going to see that when we get to Alameda, that is different than Contra Costa. So they made an urgent release. All court locations will reopen to the public on May the 26th at 8 a.m. If you are sick, now listen to this, if you are sick, do not come to the court. No one who is sick or who is exhibiting COVID-19 symptoms will be permitted to enter any court facility. You must wear a mask or face covering to enter any court facility at all times while inside. Remember this, they are not going to let you in. So if you have a hearing and you're supposed to be at the court, make sure that you have extra extra face mask, extra gloves, extra everything in your car. So that's not an issue of when you get to the court, wow, I forgot it, because they're not going to have it available to give to you. If that's the case, they will be giving it to every single person that's there to attend court hearings. So make sure that you do not run out the house or leave without having the proper items that they're asking for. Anyone entering any court facility will have their temperature taken. Remember they're going to take your temperature. If you have an issue with it, they're not going to let you in the court. There's no need in arguing or debating with the people who will be administering it, which would probably be the sheriff that checks you in at the entry. So you don't want to get arrested for not letting your temperature being taken, or get into an argument with the sheriff who is who's usually there, allowing people to get in and checking and all that stuff. So don't turn that into an issue, because then you might not end up getting inside and attending your hearing. As it says, if you have a temperature of 100 degrees or higher, you will be denied entry for that day. Please accept long lines and long wait times. The court will follow social distancing requirements. You know, so much space between everybody. So it's going to even take longer, because keep in mind, the people will be distanced. It will take longer to move the lines along. So don't get upset, don't get mad, don't get flustered. If you have a business at the court, anticipate being there for hours. Don't be upset, just follow the rules. Please obey all signs. Your patience is appreciated. This is the press release that was released by Contra Costa courts. Clerks' offices are open from 8 a.m. to 2 p.m. with phone hours from 10 a.m. to 2 p.m. until further notice. That's going to probably vary from different departments, so you might want to double check that. That'll be online. The Martinez Court Records Office remains closed, so you will not be able to get records. So say, for example, and this is just an example, this is non-related to what I'm saying right now, but say, for example, you are a divorcing homeowner. The title company is going to require a copy of your judgment, your dissolution judgment. So if you know, as a divorcing homeowner or as a home buyer, if you've been divorced within the last 5 years or so, maybe even longer than that, just make sure that you get a copy of it in advance before you go into escrow, because the records department is closed in Contra Costa. If you're buying in Contra Costa, the records are closed. So you're gonna need, I'm telling you right now, you're gonna need a copy of your dissolution papers, unless the title company can get around it, which they may be able to. Talk to the escrow officer. There's alternate processes and procedures that will allow you not to have to get the copy of your judgment, but you definitely want to get to working on this right away and ask the title company or escrow officer, if you've been divorced, are you going to need to submit a copy of your dissolution judgment? Please to read, you can go on the website and read the remainder of this. It's pretty detailed. It's got a lot of instructions. I just wanted to touch on this, the major parts of it, how it's impacting the court system and the judicial process with probate sales. Also, we're going to touch on Alameda. Alameda's got a whole totally separate set of rules, even though it's in the Bay Area. Again, I highly recommend that you check the court's website for updated rules, as they are subject to change. Now listen to this. The Superior Court of Alameda County Court announced that beginning June the 1st, 2020, it will resume or expand numerous court functions, effectively reopening to the extent that court business can be conducted remotely. I bolded that so you can see that it remotely. So you will not be going to the court in Alameda like you will be going to the court in Contra Costa, within existing resources and technological limits. However, due to the Alameda County's ongoing shelter-in-place restrictions, public health concerns, the court and its clerk's office will remain closed to the public. So while Contra Costa is being a little more relaxed, in that it will allow the public to come in, Alameda is saying no, beginning June the 1st, that they will be reopening it, but not to the public. Court and its clerk's offices locations will remain closed to the public. So you will be able to process paper, but it will not be to the public. So you'll probably be mailing your documents to the court, or they'll probably have drop boxes. They'll have something. You just have to go and check and figure out what that is. If you have an attorney, your attorney will know the procedures and processes for that. And if you don't have an attorney and you're in pro per, you have to read the rules and learn. I'm Agent Q, Quintella Griffin with Better Homes and Gardens Real Estate. I'm a certified probate real estate specialist. And it's not just my job to sell, but my job to understand the processes of real estate when it comes to selling probate. It can be complex. If you'd like a appointment with me, please feel free to give me a call at 510-295-9298. Again, I'm Agent Q, Quintella Griffin with Better Homes and Gardens. You can reach me at my email address, which is agentqrealtor@gmail.com, or you can just book an appointment with me right now online at go to my calendar at https://calendly.com/agentqrealtor-1. If you go there, you'll have my calendar and you can book an appointment. I have increments of 15 minutes, 30 minutes, an hour. So feel free to book an appointment with me. And I thank you for watching my presentation, and have a great evening. Bye now. Do you have any questions? Is there anybody online that has any questions about anything that I said?